But it is my pleasure now to bring in attorney Kate Hartley from the Pacific Justice Institute to talk about a bill that that kind of popped up. It kind of snuck into the ether here, but this is an incredible bill. And when I learned more about the history and about what all this means, I couldn't wait to bring Ms. Hartley on here to talk about it. So I don't want to steal the thunder about what this bill is all about. I want you to kind of explain it. And I've got the bill printed out. I've got questions about this, and so I really want to figure this out. So Kate, welcome to the program. What can you tell us about this bill? Set it up for us.
Thanks for having me, Matt. This bill essentially would provide a cause of action under the Idaho State Constitution, specifically only related to the free speech and free exercise of religion clauses within the Constitution. So right now in the state of Idaho, specifically with free speech, there is not a state cause of action. So in other words, what that means is if someone in Idaho is aggrieved and a free speech violation has happened to them by a government entity, their only option as far as filing a lawsuit to recover is to file a lawsuit in federal court under the U.S. Constitution and federal statute. So again, there is no state-based way for them to file a claim. There is a statute in Idaho where you can file a claim related to the free exercise of religion. That does exist, but there does not exist anything in the free speech realm. And there's a lot of advantages potentially to having a state claim, having that option. And one is that the state courts in Idaho can have their own interpretations, right? The state of Idaho could say, we really value free speech. And so we don't necessarily have to follow federal precedent, right? In our state courts, we can go by really, what the people of Idaho want, and they can be, and they're in theory more in tune with what the people of Idaho want than the federal courts, federal government is. So there's that opportunity for Idaho to really develop its own case law and its own precedent on free speech. And so that's a huge advantage. And just from a practical standpoint, not every attorney is admitted to federal court. Not every attorney wants to deal with federal court. And so I think people who are aggrieved are going to have more options of people who may take it on for them if state court is an option.
Yeah. So let me break that down for us. So if you feel like the government at any level, whether it was, your city government, your state government, the feds, whoever violated, your free speech rights, right now in the state of Idaho, the only place that you can go would be to file in a federal court. And then be among 50 states that might be doing the same thing with people all over the place. So the chances of and the length of time that it would take to find recourse in that avenue, you're saying if we do that at the state level, you might have a better chance of being heard. You might have a better chance of having an outcome and having a more local feel to your claim against the state. Is that?
Agree. Definitely there can be a local feel. And again, Idaho can develop its own precedent. So a state court, deciding a case on free speech, in Idaho state court does not have to follow federal precedent. Whereas when you're in a federal court, that's not the case. You have to follow federal precedent. So if Idaho courts want to say, again, we really value free speech and we are going to go even farther than, what federal precedent says on this issue, they can do that. And again, like I said, at least in theory, state court judges are more in tune with the flavor of our state than federal court judges are, right? Federal court judges, for anyone who doesn't know, federal court judges are appointed by presidential administrations. Right. And so even here in Idaho federal court, those judges are appointed right now they're being appointed by the Biden administration. So you can imagine what is coming into our federal courts right now. So I believe that is a big advantage. As someone who litigates these cases, I do think that is a potential huge advantage to the people of Idaho, just to have more options if they
Yeah.
have had free speech. And again, free exercise of religion as well. We're going for that just because we really believe, why not have another recourse in that arena? There's nothing bad that can come of that. And so,
Yeah.
uh,
Absolutely.
yeah.
Absolutely. Absolutely. Yes, you are. And we've had you on a few times and maybe I didn't properly introduce you, but this is your area. This is First Amendment. This is what Pacific Justice Institute is all about. This is why we have you on to discuss this kind of thing, is because this is your area of expertise here. And so, okay, so I'm looking at the bill. And there's when you read through a bill, a lot of times they'll put in what the legislative intent is, and this what it states here is that current law does not provide a mechanism to enforce these rights against government entities, and so this is essentially the intent of the law is that we're recognizing that there is no mechanism for Idahoans to sue the state when their speech is violated. So, do you have any examples of something that happened in Idaho that could have fallen under this that no one was able to take care of?
Definitely. I have a number of free speech cases myself here that, again, have been filed in federal court because they had to be.
Right.
And do I know of any cases where someone couldn't find any way to recover? That I can't say, one way or another. But what I can say myself is that I have a number of free speech cases in our state, and they're all in federal court because that's the only option.
If this law was already in effect, you think, for instance, I think there's that case out in Kellogg in Shoshone County up here in the north with Travis, who spoke out at his school, said men are men, women are women, there's no in between, and then got punished for that. That's a specific case that could have been brought against the state rather than it being stuck in federal court.
Absolutely. So that could have been brought in state court, or at a minimum, a state law claim could have been tagged on to the federal claim. So it's just more options, more ways to recover damages for people that have been aggrieved. Again, Travis Lore is a great example, and a number of other cases like that. And, it just is good to have options. Again, I think a lot of attorneys don't have any interest in being in federal court, dealing with federal court. I'm there all the time, so I guess I'm used to it, but I understand. I mean, you can only do so much, right? And so the pool of people to help them, I think, is going to be smaller simply because you have to utilize federal court. So yeah, to answer your question, that was a long answer. I'm sorry, but yes, I have numerous cases that this would have applied to. Yes.
Okay. Great. Because, we hear a lot of times when bills get before people that some detractors will say, well, this is trying to solve a problem that isn't occurring. And it's like, no, this one is definitely occurring. and just today, or last night, I tweeted out, because we were speaking about the mask mandate bill, prohibition bill that's going through the system right now. And there was a big hearing on it yesterday. And I had a couple folks in my in reply to me on a post on X saying that that there should be a way for us to sue these people who put these mandates on us or who restrict us in a certain way. And I told him, I said, you got to tune in tomorrow because this is the beginning of something. It may not cover everything yet, but this is the beginning of something. So let's deal with the First Amendment first and see if we can get this through. I do want to point out to you the exceptions, right? Because you're going to find, the purists that will read the law and go, oh, what are these exceptions for? Now you're just putting into law a way for the government to restrict our rights. And so I want to point you out to page 2, lines, I believe on line 17 here. It says any government entity or employee may substantially burden a person's exercise. And then it goes on to say, as long as the government is it's essential to further a compelling governmental interest, and is also using the least restrictive means of furthering that compelling governmental interest. So I wanted to address this because I know there's going to be these purists out there that are saying, what do you mean? Like there should never be a reason why the government would restrict your First Amendment rights. Why are we giving someone an out? Can you address that a little bit?
Yeah, that's a great question. So this language is consistent with federal law and also our state's free exercise of religion statute that's separate from this. And really what this means is that the government can step in if someone claims that something they're doing is part of their religion, right? But it is very problematic. So the example I always use is if someone believes as part of their religion that they have to murder children, okay? The government in that situation can step in and say, okay, we as a state have a compelling interest in preventing the murder of children. And so yes, okay, you're saying that is a religious practice that you have a belief in, but we think that our interest in preventing the murder of children is it trumps that, right? And this is reserved for pretty extreme. I mean, that example is very extreme, but it is a difficult bar for the government to prove that it does have a compelling interest that overrides our free exercise of religion.
Okay, so, and we discussed this last time you were on the program, the compelling interest.
Yes, I get a lot of questions about this, and it's a great question. I mean, because to understand when the state truly can step in and say, okay, this is a little bit too far. Right. And this is why. And again, it is a high barrier. It's a very high barrier for the government to show that they have a compelling interest and that they are doing that in a way that's narrowly tailored, which means it only is addressing the very specific thing there's a problem with. So you as a lawyer defending somebody or prosecuting the government for this, the burden would be on the government in that case to say, oh, no, we had a compelling interest. And you're going to be there saying like, no, you had no compelling interest to tell a high school student that he couldn't say what he said. Correct. Right.
Okay.
You got it. Exactly.
So, okay. All right, good. So that kind of stuff will be hashed out in court. So it wouldn't stop somebody from hiring an attorney or filing a claim in this sense. Okay.
Exactly.
All right, good. The other thing is who's ultimately responsible. It makes me think of the term, I'm just doing my job, right? And so when somebody violates someone's rights, and usually we see this in like police brutality cases or something like that, where someone says, well, I'm just doing my job. Okay, so who is ultimately going to be responsible in here? And I noticed that the liability entity here is the government, but is there anything that happens to the individual who's working for the government that is the one that violated the rights? What are the difference between the two in this law?
So if the individual who I guess was the decision maker or whoever initiated the violation, we'll just put it that way, and every case is a little bit different, but if there was a specific individual who was responsible, but they were acting within their official capacity as a government employee, okay, then that would the liability would fall onto the government. If that person was acting outside of their scope of employment, then that would change that scenario. So then that would, put the individual potentially at risk as well. But I mean, generally speaking, these people act within their job scope, right? And so then that would mean their government employer, whether it's local, state, whatever they are, it would fall to them.
Okay, so if the state of Idaho had like an Anthony Fauci type character who was, doing, violating people's rights by insisting that the city has to do this and the city has to do that and violate your rights in a certain manner, is there any recourse in this law against that person? Like, do we then get to tell the government you have to fire that person or you have to send them to jail or whatever? I mean,
no.
No. Okay.
No.
So, so what's the recourse against an individual? And this might be out of the scope of what we can do here. I mean, it's like, public flogging or tar and feathering. I'm not advocating that per se, but that's kind of the feeling that people get. Like, why do these people get to just walk away, and then the taxpayer, quote unquote, is on the hook for all of this? How do we deter this stuff from the actual people who are the ones violating in the name of government?
That's a great question. I hope something like this is a deterrent. To your point, that's obviously an internal decision by the government. Do we fire this person? Do we discipline this person? There's not always a lot we can do about that, to be honest. I think my experience is that a lot of this stuff happens and no one wants to challenge it. And so they kind of, the aggrieved individual may just say, okay, this is wrong, but I want to keep my job and I want to keep going and I don't want to rock the boat. And that is why I think it continues. And I've seen that a lot. And so I think those people who are willing to stand up and say, no, this is wrong, and someone needs to be held accountable at least in some way, that is what I think really helps change things. And my impression is that I think government entities get so much pressure from the left, to do this or to do that, or we're going to sue, we're going to do this. And I think if there was more of that coming from the other perspective, it may even things out better. And I do think that is somewhat of a deterrent. Yeah. I don't know if that really answers your question, but
no, it does. And I realize I'm putting the cart before the horse here and trying to go right after these individuals. But this is the reason I think this is just so important, and I think most people out there should follow this bill and support it, is because it has long-term ramifications of deterrence. And this mechanism that says, you know what, we are not going to allow our government agencies to keep violating us without having some sort of recourse. So I think that this is a fantastic first step, especially when it comes to taking on the First Amendment and protecting that. A couple, just maybe two last questions here, real quick ones. Any other states across the union have this, or are we lagging behind? Are we the first out of the gate? Where does it stand across the country?
It all looks pretty differently. Yes, some states do have an ability for a cause of action under their state constitution, definitely. And that looks honestly differently in various states. So I would say, this is not out of complete left field by any means for us to have something like this.
Okay.
Yeah.
Great. Good. That's always good when they're trying to defend this in committees and stuff. Okay. This had a print hearing a couple of weeks ago, I think, or a week ago or so, and it actually didn't have an actual hearing. They just blanket said, oh, let's just print this and we'll have a hearing later on. So we know it's coming back. Senator Ben Taves, his name is on this. Representative Bruce Skog, his name is on this as well. And he's the chairman of the committee that this would be before. So we expect, and I heard that we should expect to see this bill have a hearing on Monday. So if that's the case, then we will definitely check out that hearing on Monday and see what kind of hubbub this does. We'd be surprised. Maybe it'll just sail through, or maybe we'll get some pushback. Do you expect there to be any pushback? I mean, what ideologically speaking, is this something? I mean, this feels like something that all ideologues could get behind.
You would think so. I mean, I would think that the area of pushback may come from people saying, okay, at least to the free exercise of religion portion, okay, we already have a state statute. We don't really need this. I wouldn't be surprised if we hear that. And I guess if that pushback was severe, we could remove that. It's possible to remove that part and maybe just go with the free speech route, just to get something down there. Again, there may be no pushback with that. I have no idea, but that would be unsurprising to me if there's pushback related to that. It seems like there's always pushback related to adding causes of action.
Right.
I'm sure that so there certainly could be that going on. And definitely, if they argue that this is not happening in Idaho, I'd be happy to correct them on that. But hopefully they're aware that there are problems in Idaho with this that need to be addressed. But we'll see. I'm very interested to see what the reaction is myself.
Yeah, we all are. Well, so far we got good reactions on this side. So I thank you for coming on and explaining some of this. I think I got all my questions out about this on here. But I'm certain we'll hear some rumblings if people still have an issue with this. But I don't see any problem with it right now, and you've explained some of the problems away for me, if there are any. So, Kate, thank you so much for coming on. Where can people find you? Where can people follow your work or get a hold of you if they need, if they have some free speech issues and religious persecution issues?
Yeah, our website is pji.org. And if you need legal help, you can certainly request legal assistance at that website. And if you're in Idaho, they will get a hold of me.
Fantastic. All right, folks. Thank you so much, Kate, for joining us. And we'll have you back and we'll check in on all the other things we've been talking about too. But it's good to see you.
Thanks, Matt. I appreciate you having me.
Okay. All right, folks. That's House Bill 517. House Bill 517. So pay attention to that. I think we're going to hear it in committee on Monday, and if we do, we will make sure to follow that and bring that to you. Very important stuff. This is what we're talking about when we talk about, not getting caught up in all the noise. These are the things that are vital. These are the things that are vital. They're creating a foundation to fight all these other little battles and to really push back on the establishment. So House Bill 517 is crucial, and this might set the precedent for other areas that we can have mechanisms for redress against our government, not just yelling into the ether or showing up at meetings and being like, "What can we do?" Well, now you can do something, and we thank people like Kate Hartley who work for an organization that fights on behalf of the First Amendment in this particular case. And so this is very important. We could sit here all day and talk about genders and pronouns and cannibalism and whatever, but we're not going to do that. We are going to focus on what we feel are the most important bills, and you're going to see pushback on this stuff, especially with the budget. When we spent 2 weeks talking about the budget process, and people were like, "Oh, this is kind of boring, or it's not very important." It was so important they got rid of their majority leader. Okay, this stuff's important. We've got our fingers on the pulse. I'm watching your comments. I've got people texting me and sending me emails. We are steering the ship forward. There will be no distractions. No distractions. We are moving forward. We are going to take a quick break. And when we come back, we are going to check in with some more folks, find out what's happening on the floor, and just more to come. More to come. We'll be right back.
It's our job to maintain the proper role of government and what we were tasked to do.